Okay, we're going to get started today with just a very broad overview of the American legal system. And obviously, that's a massive topic, but really what I want to do is just start to lay the foundation for the types of things we're going to discuss in the class throughout the weeks here. And, just give you sort of a base to build upon in terms of how our legal system historically formed and how it's evolved and some of the different elements of it. So, to do that, I think we really need to start off with just coming to an agreement on what is law, right? It seems like maybe it's an obvious question, but also we know it's a hotly debated question in a lot of areas in our country. So, this first definition, and obviously there's a lot of different ways that people could answer that question, but there's a specific reason I like this one. Any social norm or organized, ritualized method of settling disputes. Now, I don't know that I would say that applies in modern time today necessarily, but if we take this definition and we take it back to, say, the 1800s, when there were a couple of ranchers and one stole his neighbor's horse, well, how might they have settled that? They might have said, okay, we're going to meet down at the saloon at noon and we are going to duel with pistols to the death. Now, that might sound crazy today, but if you look at this definition, it was very organized, it was certainly a ritual, and it was absolutely a method of settling disputes that at the time was a social norm. So I just kind of like that sort of comparison there. But this is really what I think gets interesting. And this is what law is, right? It's social engineering. It's really an attempt, it's geared towards ordering the way that people behave. And obviously, lots of examples of that. If we didn't have speed limits, how would people drive? If we didn't have drinking ages, who might drink or not drink? Essentially, if everything was legal, if drugs and just guns were unlimited and all kinds of things, there were no laws restricting things. Well, why do they restrict them? Because it's an attempt to order the way that people behave. Sometimes it works, sometimes it doesn't, but it's absolutely social engineering. And then, probably the most traditional way to think of what is law is that it's just a set of rules that attempt to guide human conduct and a set of formal governmental sanctions that are applied when those rules are broken. And it's the second part that's key, because if you have a set of rules, but you don't have any punishment, then what does it really matter? You'll hear the phrase, well, that law doesn't have any teeth to it. And that's kind of what it means, right? I mean, you might have a law in the books, but this critical part of it is to have that formal government sanctions, essentially to incentivize people not to break the law, right? So let's talk a little about where this all came from. And probably not shocking to you, the origins of our American law came from English common law. And so in England, the church was incredibly powerful. So church law was a big deal, whether they were, legislating over primarily things like morality and the Bible and things like that. But for areas that the church didn't care to get involved in, that's where common law came into play. And it was built essentially off of the idea of the customs of people were used by the king's courts as the basis of law, right? So it was discovered law. It was something that was built over time. As those customs developed, the law kind of came to be from that. Now, sometimes there weren't customs, and so what happened in that case? Judges would just create the laws themselves. It might be kind of scary sounding today, but that's just the way it was done. And just to sort of draw a loose parallel, some folks might say that the executive order that the presidents have in our country, it doesn't allow them to create laws per se, but there are people that kind of see a parallel there, where they can sort of circumvent Congress and sort of create, or at least create some lanes of laws by themselves. Common law, the thing about it, it's inductive, right? Legal rule is arrived at after considering many cases. Now, remember, we talked about the customs of the people, and that's the same idea, right? They take many cases and deduct to get to their conclusion based on what happened in those previous cases. The big thing, common law can adapt, and it does change. And that's very important. As society changes, as we evolve, as all kinds of things happen, it's important for common law to change and evolve. Really good example of that would be here in New York State. historically, there was something, if someone got bit by a dog, that'd be a personal injury case, and you might sue the owner of the dog. So there was a rule kind of informally, it was a common law rule called the one free bite. And what it essentially meant was that if my dog bit you and you couldn't prove that I didn't know my dog was violent, essentially, largely, I wouldn't be held liable for your injury. Right? That was common law. And in 2025 in New York, that adapted and changed. And they came out with a new rule that said, no, that's not it anymore. Now you are responsible from the get-go, from that first bite, more or less, right? So that's an example of a common law, but also an example of how it did adapt and change with the times. Now, a little Latin here. Stare decisis. Very simply just means let the decision stand. This is a huge, important part of our legal system. You hear the idea of precedent talked about all the time. It's really a kind of a bedrock foundation of our judicial system. So judges, they look to the past cases. They want to follow what other judges have done. Now, sometimes when we say precedent, right, what precedes us, so decisions that were already made. So if a judge today has a case in front of the court, and there's got to be a question of law to be answered, they want to look back and say, similar cases like this have happened, of course. I want to look back through the case histories and see how those judges ruled, and then I'm going to follow that precedent and rule the same way that they did. And that's why you'll hear the phrase establishing precedent. So sometimes there's a case that's so unique, there is no precedent, and then it becomes a precedent-setting case, right? But it's in common law, very much precedent is a critical part of how courts rule on these things. Ideally, best case scenario, the judge should resolve the issue before the court following the precedent that was set only when similar problems were adjudicated in the past. So what happens is there's a lot of cases where a judge will use precedent that doesn't exactly align with the current case before the court, but they interpret that it does, and that can be problematic. So ideally, they really should only use it from cases that align very closely to the case that's before them. Now, what's the inherent flaw in the system of using precedent? It's pretty big and it's pretty obvious. And that is, what if the earlier rulings were flawed? What if they were bad decisions? Certainly courts make mistakes. And if those early cases were flawed and then other courts going forward build off of that and essentially support it and add to it, you can end up with a really broken system because it's all built on an initial flawed foundation, that first case or those early cases. And that's a big concern. It's, the justice system is not perfect. Hopefully more times than not the courts get it right, but this is an issue that you see come up. Typically speaking, when a court has a matter before them and they have to decide how they're going to handle precedent, there's generally four options that they have. The first and most basic, obviously, is they follow precedent. They look what came before them, they align it with the case in front of them at the time, and they simply follow precedent. The next is they can modify it. They might look at the precedent that's put before them and say, okay, mostly this aligns and I'm going to follow that. But in the case before me, I'm going to modify a little bit. I'm going to go a little off in this one area or these two areas where I think it's a little bit different. So they'll largely follow the precedent, but they might carve out a few paths on their own. The third would be they can be distinguishing. And that is to say, you know what, people think that this should be precedent to this case, but it's not, and they're going to distinguish the facts that are different or the reasons why they believe the current case doesn't line up with the previous cases. So they're going to distinguish and outline differences to essentially say why they're not following the precedent. And the fourth is they simply can overrule. They can say, no, the precedent was wrong. Go back to my first point. What if they were flawed? And the court can simply say, no. You'll see an appeals court do this. You'll see it all the way to the Supreme Court, where they'll look at the precedent of the lower court and simply say the court erred. They were not right about this. The most famous example in recent time, of course, would be Dobbs versus Jackson's Women's Health Organization in 2022, which was a landmark Court case that did overturn Roe v. Wade, itself a landmark Supreme Court case 50 years earlier. And essentially, the court ruled that the earlier decision that Roe v. Wade was flawed. And so that's really an excellent example of a court overruling itself and changing direction. So we're going to talk about the different types, another type of law, and that is equity law. So we talked about common law, now we're going to talk about equity law. Again, not shocking, goes back to our British roots, developed in the 14th century. Here, rules and procedures of equity, they're more flexible than common law. They permit the judge to create a solution if there's a unique situation, okay? Why do I have Tom Brady up here? Well, you'll find out in a second. But the key is there's no jury. The outcome is based on judicial decrees, what the judge decides. And again, that's that flexibility if there's a unique situation. Ultimately, equity law is about restraining an individual, a corporation, or even a government from taking an action, restraining them. They're stopping them from doing it. And so, cut to Tom Brady. Very, very famous case if you're a football fan, but really a case that had broader implications was when Tom Brady played for the Patriots. There was a case that became kind of colloquially known as Deflategate, and he was accused of deflating footballs to give his team an advantage. The league suspended him, and Brady went before the courts and he asked for an injunction. He wanted the court to restrain the corporation, the NFL, from suspending him so he could continue to play. And here's a great case of equity law where the court heard the argument, and they actually did. They issued a temporary injunction, meaning he could continue to play football, and they stopped the NFL, the corporation, from suspending him. Now, ultimately, the NFL appealed, and the next court overruled the lower court, and they threw that out, and ultimately he was suspended. But that's a good example of equity law, restraining an individual, a corporation, or government from taking a specific action. Now, statutory law, these are the ones that we're all most commonly familiar with. All right, they're laws created by a legislative body and signed off on by the executive leader. Okay, so in this case, if we're talking the federal government, they're laws created by Congress, signed off on by the president. If it's New York State level, again, created by the state legislature and signed off on by the governor of New York. Statutes tend to deal with problems that affect large groups of people, right? So common law, smaller, individualized problems. For Congress or for the state legislature to go through and create these, they tend to be addressing larger societal issues, okay? Statutory laws can anticipate problems and be proactive. So let's go back to the idea of speeding. It's fairly easy to anticipate that if people are all driving 100 miles an hour in the thruway, that's going to be a problem. So we're going to get proactive and we're going to implement a law to limit how fast people can drive. Okay, so that's just an easy example. And again, all criminal laws in the United States are statutory laws. Statutory laws are collected in books and oftentimes called codes, and that's important, right? You've ever heard, we're going to throw the book at him, right? Or we're going to go by the book. So in order for someone to be arrested, charged, go through the judicial process, it can't be left to, sort of a judge's opinion or interpretation or leeway. It's got to be a law that's on the books that has been established to be illegal, and therefore you violated it. So statutory laws are on the books, so to speak. And let's talk about statutory construction, sometimes called statutory interpretation. The problem with laws, and really all government documents as they're written, is they oftentimes have vague language. So there's often cases where the court will have to intervene in the process and they need to interpret what a law even means. Not that it's exactly the same, but we'll take the Second Amendment or the First Amendment or any of the amendments. But the Second Amendment, the right to bear arms, right? There's constant debate over what that really meant and how it should be interpreted. But when it comes to laws, a really good example. Let's say that there was a law, could be a state law or a federal law, that says it's illegal to distribute obscene magazines in a community or a state. Okay, seems pretty straightforward, but then there becomes a problem, and that is who gets to decide what constitutes obscene, and even who gets to decide what constitutes distribution, right? So that's where the court may have to step in and start to interpret. I might think distributing a magazine means you mail it or you ship it to somebody or you drive it in a truck and it's distributed like an Amazon delivery. But then another court might argue, well, no, if you photocopy that magazine and you share it on social media, you have distributed it. So again, the courts would step in and they would interpret what those laws mean. Now, I'm breaking this up into two sections today because I don't want it to be such a long video that I kind of lose you. So this is really just part one. And this last slide, I want you to think about this for every lecture video that we do. I don't want you to just kind of rush through them. I want you to just ask yourself these few quick questions at the end. Did I understand everything that we talked about? And if you don't, that's okay, right? That's why we're here. But take note of what you didn't understand or what you were a little confused or uncertain about. Go back and watch it again. Or take that issue and just do some research on your own, right? Get out there and do some quality research and find information that's going to help clarify. After you've done that, if you're unsure, uncertain, a little muddled on something, please reach out to me. Whether it's email or text or however you want to get a hold of me, please reach out. Don't move on confused about any issue. And again, that applies throughout the semester. Because again, it's very important, anything presented in the lecture videos or in any of these assignments, you can expect it's going to appear down the road. Maybe it'll be in a quiz, maybe it'll be in the form of another assignment or the midterm or final exam. So it's also going to be information that you're going to incorporate into the papers that you write down the road. So again, you're going to have a lot going on. You've got a lot to juggle. This is a 15-week course squeezed into 7.5 weeks. So you're going to have a lot of work. Don't rush through it to the point that you're confused or missing things. Take the time to make sure that you're comfortable with what we talked about before we go on to the next one. And with that, take a break and we'll see you back for part two of this opening presentation.